applicant in the appeal Richardson and another against the Director of Public Prosecutions.
Lord Hughes will summarise the decision of the court.
The two defendants in this case deliberately trespassed into a shop in London to which they had a political objection. They immobilised themselves there using a concrete tube, a chain and a padlock. The object was to stop the shop trading, and in that they succeeded. They were arrested for the offence of trespassing coupled with the obstruction of lawful activity. They didn't dispute what they had done, but they said that it didn't add up to the offence. Their political objection was to the fact that Israel has for some years occupied land outside its internationally recognised boundaries, known as the occupied Palestinian Territory. This shop in London sold beauty products which are made by the shores of the Dead Sea in part of the OPT, the Occupied Territory. The offence which the defendants were charged with consists of trespassing and obstructing a lawful activity. The defendants said that the shop's trading wasn't lawful, and they said that offences were being committed of one or other of four kinds. First, they said that the shop company was guilty of aiding and abetting a war crime committed by the State of Israel, that is to say, occupying the territory and moving some of its nationals into it. Secondly, they said that the shop company was laundering the money proceeds of that crime. Thirdly, they said that the shop company had been guilty of cheating the tax system because the products had been imported into the United Kingdom under a European Union arrangement which applied to goods from Israel, whereas it was said these goods aren't from Israel but from an illegally occupied foreign territory. And fourthly, they said that the shop had committed labelling offences. The products were all labelled, quote, made by Dead Sea Laboratories, Dead Sea, Israel, unquote. That was said to be contrary to two sets of labelling regulations designed to protect the public, because the place was not in international law Israel, rather it was occupied territory. The main question for this court it was this: when is there enough connection between any offence committed and the activity which a trespasser disrupts, so that it can properly be said that the activity is not lawful and the trespasser is therefore not guilty of this particular offence? Will any offence do, however remote it may be from the occupier's activity, or however technical it may be? Or must the offence be integral to the activity carried on by the occupier before it becomes relevant? That was the main question, and secondly, the court had to look at the particular offences which were suggested in the present case. The answer unanimously given to the main question is that an offence takes away the lawful character of what the occupier is doing, if but only if it is integral to that activity. So that, for example, in another reported case, when a person disrupted authorised tree felling that was going on to clear land for a new road, it wasn't enough that one of the chainsaw operators wasn't wearing gloves, even if that may have been a safety at work offence. The core activity of clearing the land was authorised and lawful. Similarly, in the present case, the war crime argument, even if the offence had been made out, would have been about an antecedent and remote offence, which couldn't affect the fact that selling goods in a shop in London is a lawful activity. In fact, the war crime argument couldn't in any event help the defendants in the present case. That's because the most that could be said was that the factory company, had taken advantage of the occupation to run its factory and had employed people, some of whom may have moved from Israel. That would not be aiding and abetting the unlawful occupation of the West Bank, because aiding and abetting means encouraging it, not setting up in the occupied territory afterwards. Moreover, it would have been the factory company, not the separate shop company, which was doing it anyway. Similarly, the price of the goods charged in the shop couldn't be said to be the proceeds of any crime committed by the shop company. The importation of the goods was similarly antecedent to or collateral to the selling in the shop. If it was done under the wrong umbrella, it might leave the importers, whoever they were, liable to pay up the unpaid duty to the revenue, but it wouldn't make the selling of the goods in the shop unlawful. Nor, in the end, could the labelling regulations save the defendants in the present case from the offence that they had committed. There were two sets of regulations. The first depended on proof that the customers would be misled into buying when otherwise they wouldn't have done. The judge in the court of trial here had found that there wasn't any reason to think that any customer, assuming she was willing to buy an Israeli product from the Dead Sea, would then refuse because the label didn't specifically say that the Dead Sea factory was in the occupied territory. The second set of regulations was designed for consumer safety. It required the country of origin to be identified along with the manufacturer, and that was so that the customer knew where to complain if she needed to. Here the manufacturer was identified and the address was given. To say that the Dead Sea area was given the wrong political status because it was described as Israel didn't make any difference to the customer's ability to find the manufacturer and complain. So there probably was no breach of either set of the labelling regulations anyway, but even if there had been, these offences were tangential, collateral, not integral to the selling. So it follows that the defendants had been correctly convicted and their appeals had to be dismissed.
Thank you. The court is now adjourned.